Okay, so we're going to be covering contract law, very important for you as an individual, if you're in business, whatever. The way I like to look at these subjects, and you'll see I use the term life cycle, so you understand how, for example, a contract is formulated, um, executed, how it's terminated. So think of it as a life cycle. So we're going to be talking about contract law, which is based on common law. You understand there are four sources of American law, Constitution being number one, the U.S. Constitution, statutes, administrative law, those are regulations and administrative hearings, and then we have this common law, which are court decisions that accumulate over time. They are put together in books called restatements. So there'll be a restatement of contracts. So you don't have to read all the cases. There's these people that put it together in a restatement. Anyway, four basic elements for an enforceable contract at common law. Now, these four basic elements are going to be relevant as we talk about other contracts that are affected, I should say, by statutes. Remember, common law can be preempted or modified by statutes, and we will be talking about that. Nevertheless, common law is critical. It is the foundation for these other areas of law we're going to be studying. All right, so the four basic elements of an enforceable contract at common law. This is the key question. Do you have an enforceable contract? These are my four and I think make sense because first you ask legality. Does the proposal, does the offer violate some statute or this broad concept of public policy? Is it what you'll see is called unconscionable, that it's so outrageous it may not be illegal, but it's by statute, but it's just more or less it is inequitable. It's just outrageous. So legality. And when I say legality, we slip into the second element, capacity. This is the who. Who are you dealing with? You always want to nail that down. Never assume. Is it a natural person like you and I, a human being, or is it a legal person like a corporation? You should always verify if you're dealing with a legal person like a corporation or some sort of limited liability form of business like a limited liability company or something like that, that you verify with the state Department of Revenue and the Secretary of State that they are indeed legit. You'd be surprised, often they're not. Okay, the agreement itself. So let's talk about the agreement. So understand that a contract's a voluntary arrangement. There has to be voluntary consent. And what the courts talk about, meeting of the minds. And this is judged objectively, not what one party thought was going on, but what would an objective third party like a court ascertain from the activities of the two or more parties. Okay, so the offer, I'll just say the offeror. The word has or at the end, but the offer is made by the offeror. Or is a suffix. It at the end of the word means one who. So you're going to see that suffix used elsewhere, but or means at the end of a word, it means one who. So the offeror is one who makes the offer. As I put in here, the offeror is master of the offer. They can put whatever they want in the offer so long as it's legal. So that's important to understand. Acceptance at common law, again, we're talking common law, has to mirror the offer. It has to be unequivocal. If you deviate, the parties flip, and the party who deviates from the acceptance becomes now the making an offer in the offeror. That's a counter offer. You'll see other terms, promisor, promisee, etc. All right, so let's talk a little bit about the other elements. The last element is called consideration. Consideration is defined as the bargain for exchange. Normally it's money, but it can be what's called forbearance. I offer you a job, you give up looking for work to your detriment, and I pull the plug and say, I'm not going to hire you. That is sufficient to establish consideration. You'll see there's another term that can be applied there is, and it's at the end of this short list, but it's called promissory estoppel. And oh, isn't it? Yeah, right. Promissory estoppel. If you detrimentally relied on an offer, that's that would be viewed as consideration because of the forbearance. All right. So getting back to other things with respect to contracts that you may see. First of all, it's always important to identify who is involved in the contract, who's the offeror, who's the offeree, who's the promisor, who's the promisee, who's involved in the deal, because you can have what are called assignments or delegations, assignment of a right. You owe me money, I can assign that right to be paid to somebody else. Very common in banks do that. If you have a mortgage, which is a loan, where you go to the bank and say, I'd like to buy a house, I need whatever, $1 million, and the bank, in theory, will do their due diligence, determine you're good for it, and they may sell your loan. And that's basically an assignment. So, in any way, delegation is a delegation of a duty. Typically, the word assignment is sometimes used to cover both assignment of a right and a delegation of a duty. There are some limits. You can't delegate a duty that's specific for the person, like teaching. I can't delegate my teaching contract without the authority of the institution because it's personal. There are also the possibility of what are called third-party beneficiaries. These are people, could be natural or legal people, who are collateral beneficiaries to a contract. Some, they may or may not be identified. So, for example, if in a divorce, the parents typically execute a parenting plan, and that may provide for benefits for their children. Now, the children aren't technically parties to the divorce, but if whomever is to provide that benefit doesn't, that beneficiary, that intended beneficiary, can sue to get that benefit. There are incidental beneficiaries that they may be harmed, but they have no standing, more or less, to do anything about it. Like if you buy tickets to a baseball game or something and it's a rain out, or the game ends early or something, you may not be a legitimate beneficiary, third-party beneficiary. Okay, contracts. It's important as we go through the life cycle. You understand a contract, as we've discussed, can be a couple of things. A contract can be oral, it can be in writing. Best to have it in writing. Some contracts must be in writing to be enforceable, and this is called the statute of frauds. Every state has it. Actually, it goes back to common law, but there are certain types of contracts that must be in writing to be enforceable as a contract. These include any interest in land. Like I mentioned, if the bank's going to loan you money, the bank is going to require you to give the bank a lien on the land, a consensual lien. It's referred to as a mortgage lien or a deed naming the bank as a beneficiary if you don't pay off the loan. The so interest in land, contracts which by their terms cannot be performed within 1 year. So I may hire you to work for me on a 3-year contract. If that's not in writing, it's going to be difficult to enforce. There are workarounds, like I mentioned, promissory estoppel could be one. There are a couple others, promises to marry. There's, prenuptial type agreements, sale of goods in excess of $500, 500 or more. That's by statute that those have to be in writing. So those are the big ones there. So, all right, contract discharge. This is, you're at the end of the rainbow here, and it can be discharged by performance under common law. Substantial performance is good enough, does not need to be perfect. We will be studying sales law, which is statutory, based on what's called the Uniform Commercial Code, and they have a very specific rule with respect to sale of goods. Those, it must be perfect, and that's a very powerful remedy for buyers. If you buy something that's not perfect, you have to inspect and reject, and we'll talk about that. Failure of a condition. Conditions are very common. Getting back to the bank situation, or if you buy a car, if you can't get funding, then that's a condition, and it's discharged. The contract is discharged. Breach. We talk about material breach. It's got to be something significant that was critical to the contract, like you buy a car and you want to make sure it is compliant with environmental regulations, and it ends up it's not. And then that's a material breach that happened to Volkswagen several years ago. Anticipatory repudiation. This is where a party signals that they're not going to perform, and the other party who is left holding the bag can treat it as an immediate breach or wait until the time of performance. Normally you want to act quickly. Okay, the agreement itself, you can discharge a contract by an agreement. Both parties can rescind mutual rescission, which would involve basically returning any consideration that was tendered, and both parties basically wash their hands and go their separate ways. A novation is a new, you bring in a new party to the deal. The original parties to a contract are referred to as the parties in privity, and a novation is when a new party comes in and replaces one of the original parties. This is beyond a assignment or delegation. This is where a new party steps in. The thing with an assignment, I should just say, is the problem is the person being assigned the right to, let's say, receive payments, they step in the shoes of the original party that made the assignment. That party is known as the assignor. And so the assignee steps in the shoes of the assignor. And why is that important? Is if there's a problem in the original contract, the assignee inherits that problem. And it's a defense for the whoever's obligated, and they can argue that. But with a novation, a new party comes in and substitutes totally for one of the two parties. It's got to be by agreement, obviously, and may involve a new agreement, which gets me to another way contracts can be discharged is by an accord in satisfaction. Now, again, laws and language. An accord is simply a new agreement. Satisfaction is with the existing parties. An accord is typically a new agreement with the existing parties. And satisfaction is with the agreement is completed at performance. So accord and satisfaction, think of it as a modification. Okay. Contracts can be discharged by operation of law. If there's a material alteration, for example, you and I have a contract and for 10,000 and I add a zero to it and I try to cash that in or use that's going to be discharged by material alteration. Statute of limitations, this is time limit. I mentioned this before. These are statutes that put a time limit on everything, criminal, civil, except for murder. And so, for example, contracts in the state of Washington, oral contracts, you have 3 years to enforce an oral contract from the date of the breach, 6 years on a written contract from the date of the breach. States have different laws and different time limits. Bankruptcy is a way to discharge contractual obligations, not all of them. We will be covering that, but some things you can't get rid of in bankruptcy, or it's very difficult, like your student loan, family support obligations, alimony, child support. You can't get rid of those. All right, a couple other ways contracts can be discharged is by if it's impossible or impractical to perform, and it's objectively impossible or totally impracticable. For example, if you're buying some goods or fruit or something and a tornado or some natural disaster makes that impossible, then that's out. Sometimes you'll see in contracts a clause known as force majeure, act of God, and that will excuse performance. Frustration of purpose, similar to impossibility or impracticability. The objective purpose for performance no longer exists due to reasons beyond the party's control. Maybe again, I go back to the weather situation. Okay, I mentioned statute of frauds. There are some exceptions to that. Among them is if the party admits they had a contract. Part performance. So there are some exceptions, but the fundamental rule here is that you should have your contract in writing and not risk an oral contract. And it needs to be signed by the party who breached it. Both parties actually don't need to sign it. Just whoever is breaching it and you're suing, they would have had to sign it. I mentioned the Uniform Commercial Code. This is a massive body of law broken up into various articles, like the Constitution. We'll be covering some of those in this lecture series. Property law, again, with respect to contracts, there are specific rules, like if you're going to sell property, the deed is the document of title showing the ownership, and that has to be in writing. Normally, there's always some exceptions, perhaps. Employment law is based on common law, agency law, but employment law, you're talking about statutes and regulations that are relevant to employees. And they include protections from discrimination, employment discrimination, wage and hour laws, things like that. We'll be talking about that. Okay, so in a contract, the goal is to make the party whole. There's different names for damages, as we discussed with torts. Remember, torts, they have specials and generals. Specials have specific receipts for, and generals are more amorphous, like pain and suffering. So with contracts, you have compensatory damages. These are to compensate for direct losses. These are akin to specials under tort law. Consequential damages are those that are indirect, foreseeable losses, like lost profits in a business for business interruption. There are damages called punitive, meant to punish. Liquidated damages, these are agreed upon by the parties in the contract. These cannot be punitive. It's smart to have that if you have enough foresight to figure it out. Nominal, these are basically vindication, small amounts of money just to vindicate a person. All right, so I mentioned those are damages. Damages money. So keep that in mind, damages money. There are also equitable remedies a court may employ to, as a matter of fairness. And these, I mentioned promissory estoppel. You see the word stop. This is where you go to court and say, for whatever reason, maybe the contract should have been in writing, it wasn't, but you detrimentally relied on the promise, maybe gave up searching for a job. The court may provide you some remedy under this principle of promissory estoppel. Another one is quasi-contract, where maybe you did work for somebody and you did not agree on how much you were going to be paid, and you get stiffed, and you can again go to court and argue that the other party received an unjust enrichment. Okay, rescission. Again, this is like mutual rescission where the parties just, go back to their pre-contractual positions, and any consideration that's been paid is repaid or restored, or what's called restitution. Specific performance, as the term would suggest, this is where you're not really asking for money. You just want the other party to do what they promised to do. This is a standard remedy with land. You buy some land, and for whatever reason, the seller does not want to give you the deed. You've already paid for it or given consideration for it. You can go to court and ask the court for a specific performance. Reformation is the idea where a court can actually reform or fix a contract to make it legal. This is also called green lining, or there's some terms for it, but reformation. So that's those are the equitable remedies there. And that's the end of this video.